Hi, everybody. It's Mike Swanson speaking to you from Music City, Nashville, Tennessee. Thanks for joining our webinar today. We're in for a special treat today because joining us is one of the more prominent trial lawyers in the Southeast. His name's Patrick Cruz. He'll be sharing information about how to maximize the results of your case. Before we get started, we always have a disclaimer. So this webinar has been prepared for informational purposes only. It's not meant to be legal, tax, or accounting advice. If you have questions about any of this, contact your own professional. I am not a lawyer, although Patrick is. So this is me. I am the president and CEO of Advocate Capital, and this webinar is brought to you by Advocate Capital on behalf of the Law Practice Channel. So without further ado, I'd like to introduce you to attorney Patrick Cruz from the Hamilton Law Firm, and he specializes in trucking accidents and car wrecks, and has been doing that for nearly 20 years. Hey, Patrick, there you are. Thanks for joining us.
Yes, thanks for having me, Mike.
Yeah, absolutely. We know how busy you are. Thank you for taking time to share what I know is some awesome information with the Law Practice Channel viewers today. And by the way, we'll have a Q&A at the end. So there is a questions part in your dialog box for the viewers. If you would like to ask questions, we'll read those at the end, but you can type them while we're going. And we'll get started. So Patrick, again, thanks for this. Your topic today is how to maximize the value of your case. And the first thing I think you want to talk about is case selection. What do you have for us on case selection?
Yeah, on case selection, obviously everything starts with case selection, and there's a certain amount of luck involved in that. But you want to be on the lookout for certain types of cases. Obviously, you want to look for any case involving serious injury and or catastrophic injury or wrongful death. And you also want to look and try to determine if you have a good client, how will that client present to a jury? And you can kind of learn a lot of that, obviously, in your first meeting with the client. And what I like to do is when a client comes in and I'm meeting with that client, I like to ask my staff what they think about the client. You can kind of get some early impressions right away.
Yeah.
So having a good client, serious injuries, obviously very important. You also want to look at the conduct of the defendant. And, you know, we put down egregious conduct. And what they've found over the years is that generally big verdicts are driven by egregious conduct on the part of the defendant. It's something that a jury feels like they can help the person out. And also there's a sort of, as one author has called it, a reptilian mode that goes into a jury when they see egregious conduct. They think, okay, this could happen to me. Now, they're not supposed to think that way, but they're humans. So if you have those three things, the next thing you're looking for is, as we used to call it, deep pockets, but basically a source of recovery. And so a good source of recovery, generally if you have a commercial vehicle involved or a corporate defendant or something along those lines, someone that's drinking and driving and working on the job at the same time, something to allow you a means of recovery and your client. So you want to hopefully have those four things and a few others, but those are the four main things.
So can I ask you a question about that? When you're looking for a good client, as you said, when I read that at first, I thought, well, somebody who returns calls and is communicative and things like that. So can you share with our viewers what are some of the things you look for in a client, qualities, and then also what kind of things you try to avoid in a client?
Yeah, it's hard to pinpoint exactly, but there's a certain aura or charisma that people have, and you want to try to read that. You also, they may not have good aura or charisma, but they may be a good hard-working person that's soft-spoken. That's fine too. But you're looking for things that are somewhat relatable to 12 people on a jury or 6 or whatever your jury number is where you're practicing. So I'm always trying to look at that. It's not the most important thing, but it is an important factor. And
yeah,
so,
I hadn't thought about that. Are there certain traits or things you don't like to see?
I can give a quick example. I had a case recently with an individual with fairly significant injuries, pretty clear liability. It seemed like a pretty good case when I first met with the guy. But, you know, we do our homework. So we do a criminal check, not just on the defendant, but on our own client. And we started doing Google research. And I probably can't get into too much details, but this individual happened to be a gang leader. And
Wow.
it was well known as I started talking to people in the community where we were going to be litigating this case, that if I went in front of a jury, someone's probably going to figure that out, and they're probably not going to want to compensate that individual. So that's a recent example, and some would say that's not appropriate to discharge someone just because of that, but that was going to drive that case, and so that wasn't one that I wanted.
Very interesting. Yeah, I hadn't thought about that. Thank you. Great. So I think next thing you want to talk about is be prepared to spend money.
Yes, and this is how you and I came to meet. I guess last year.
Yeah.
I had a number of significant commercial trucking cases, and we were spending a lot of money on these cases, and which is what we do. We want to maximize the value of our cases, and to do that, you have to spend money. So, we got to the point where we had a number of these, and we're a relatively small firm with 4 lawyers. So we didn't want our resources to slow down our ability to prosecute the case to the fullest, and that's how we reached out to you. But be prepared to spend money is something that I think you have to be able to do. And if you're not, as a lawyer, you need to be able to associate someone that can, or work with a company like your company. And that's very crucial to litigating any kind of significant case. So if you have a serious case, be ready to spend money, be ready to spend money early and often.
Yeah, absolutely. And, I think most folks, especially plaintiffs, don't realize that although maybe their lawyer seems rich compared to them, they're not rich compared to Allstate or, State Farm or something like that. And it's really not a fair fight financially. And another thing that I think that happens around the country, there are conversations inside of law firms where the partners say, well, we got payroll next week, we need to settle a case, or we have payroll next week, we can't hire that witness this week. So I think having access to capital is not something that always goes through people's minds. They want the best lawyer, but they also need to have not just the best legal tools, but financial wherewithal as well.
That's right. And if we could go to the next slide, the other kind of basic rule, and a lot of this seems basic, but it's a good reminder. When you asked me to do this webinar, I was working on a chapter in a book that was called Settlement Techniques and Strategies in Car Wreck Cases. So as I was writing the book, I kind of went back and tried to organize how I do things or how I like to do things. And so, start early, file suit early is a basic thing, but a lot of lawyers do not do it. So you want to get that lawsuit filed early, and that helps you not only with just moving the case along, which is the goal, but it helps you avoid the loss of evidence, witnesses losing their memories, things of that nature. So that's why on that slide, file suit early, don't wait. You're not really helping your client by waiting. Obviously, there's exceptions to all these rules, but that's a good basic rule to follow.
Right. So how do you make sure you file early? Do you have a system or a checklist or something like that?
Yes, and probably like 99% of other plaintiff lawyers, we use a case management program. And that case management program sets off all sorts of what we call ticklers or to-dos. And that makes us keep the case going. And there are certain cases, if you end up with a soft tissue case, that you may want to try to resolve early to avoid litigation expenses. But if you obtain a significant case, my theory and the theory of most, what I think of as being very good lawyers, is to get that suit filed early. You're not really going to obtain full value before you do discovery and really work up your case.
Makes sense.
I did want to add, and this goes on to the next slide. I did want to add, when I'm talking today, there's a distinction between what we call this maximizing the value of your case. That doesn't mean manufacturing your case. Maximizing the value of your case is to follow these precepts, and I didn't invent these, obviously, but this is what I've learned from other good lawyers. And filing suit early and preparing your case for trial and spending money, you are in effect exemplifying and proving your case. You're not manufacturing it. So I want to make that point clear before we go any further. Well, preparing your case for trial, I have lawyers, I guess I'm coming up on 20 years now, I still feel young, but I have lawyers ask me all the time, how do you prepare a case for settlement? And my answer is, I prepare my case for trial. Does that mean I try a ton of cases? No, but I get all my cases ready for trial, and I push them to trial. So as shown on this slide, you want to get with your experts early and retain them If I get a tractor trailer case that comes in the door or is referred to me by another lawyer and the wreck has just happened, one of my first calls is to an expert. I'm going to want someone that can go to the tractor that caused the wreck and download the data from the tractor before it disappears. I want to get my spoliation letters out as well, but getting that expert early is extremely important because a lot of that stuff will disappear on significant cases for whatever reason, and you want to get your experts out there early. So that's one of the first things you want to do, as shown in that slide. The other thing that people overlook, and someone taught me this when I was first started practicing, and this goes back to spending money, you need to meet with the treating physicians. A lot of people wait until 2 years after a wreck, and then they're getting ready for a deposition, and they go in there and take a deposition, and the doctor doesn't say what they want the doctor to say or what they hope the doctor would say. And you can avoid that and avoid a lot of cost if you meet with the doctors before you've even filed a lawsuit. Go see what they're like, what they're willing to testify about, what their testimony might be, and that will help you evaluate the case. It might help you determine that you need to hire your own doctor, whatever the case may be. You may learn that you need to hire a vocational expert because the treating doctor is going to put your client on restrictions, et cetera, et cetera. So it's very important that you meet with the treating providers and establish a rapport with them. The same with the next part of the slide, which I believe is get to know your client. The next one I think is meeting with witnesses, but getting to know your client on a personal level. This is another thing, a basic thing that we as lawyers struggle with, or at least I did for a long time. And I watched a gentleman, a lawyer that I hold in high regard in Atlanta, talk about having his clients over for dinner to his house. And when I heard him say that, I thought, well, that's crazy. But it hit home with me. In the next trial I had, I started spending a lot of time with my client at his house and his family. I didn't have him over for dinner, but I spent a lot of time at his house. And I got to know him and what he went through each day. And so when I went to trial, I knew what he went through. I knew what questions to ask him and the people that were taking care of him. So really getting to know your client is crucial. And you can't do it on every case, but it's something that I try to do more than I used to. If I've got someone that calls me that wants to talk about representation and they want to meet me at their house, I'm more than happy to do it. Tomorrow I'm driving 2 hours to go meet with some clients whose dad passed away in a wreck. And I don't have to do that, but I want to go sit down with the family, and it won't be the first time I've been up there. And that is very important in my mind. Witnesses, it's the same thing. You want to attach your personality to folks. Get to witnesses early. If you are waiting until a year or two after a wreck to talk to witnesses, you can pretty much guarantee the other side has already talked to them. And they may have skewed their recollection or done whatever, but they've got those witnesses nailed down. So I think it's important to get in touch with witnesses early, whether you do that personally, whether you have an investigator on staff, whether you hire an investigator, but get to those witnesses early to find out what they're going to say. And sometimes it's helpful and sometimes it's not, but you want to know one way or the other. So that's very important.
Yeah, makes sense.
The other part, get help from other lawyers if necessary. This is something that I think lawyers have a hard time doing, and I still do it to this day, is that you have to always think about what's best for the client. And if you've never handled a wrongful death case and you have a wrongful death case and you aren't consulting with other lawyers on that case, you are running the risk of not doing the best job for your client. And so I've learned this actually over the years by associating with lawyers that are better than me. And the benefit is not only to the client, but the benefit I received is learning from great lawyers, and it makes me a better lawyer. So I get questions all the time. I just had one the other day that asked me about a demand letter on a death case. And, I just thought that, if you don't have kind of the basics, if you've never done a demand letter, you might want to associate with someone that can help you do a better job for your client, and everyone will benefit from that. So it takes a little bit of swallowing of the pride, but it's a necessary, because at the end of the day, you're trying to do what is best for your client.
Right. Amen. Makes sense. Sounds good.
And I'll kind of run through these so we don't take too long, but
That's okay.
prove all your aspects of your case and start early. You can see kind of a common theme here, which is get moving on your cases. You know, consult with experts, economists, life care planners, vocational experts. Sob witnesses is probably an inappropriate term, but I used it. Those are friends and family of the victim. Okay, you need to talk with those, and you want to establish a relationship with those folks. Treating physicians, we talked about that. Medical illustrations is something I've been using a lot lately, and you know, day in the life videos, liability experts. So you can tell whenever you have a significant case, at the very beginning, you have to start again with the mindset of I need to move this case along. I'm going to have to spend money, and what experts and what things do I need to do to prove each element of my client's case and their damages and to prove liability. So what we have on this slide is just some examples. It's not everything, and every
Yeah.
case might require one or two of on this list, or it might require one or two more. So all this is very important when you're trying to obtain a reasonable recovery for your client.
And a lot of those things on that list, as I look at it, are expensive, right? I mean,
Yes.
economists, life care planners.
Yeah, and it all depends where you are, but you know, a good vocational expert will run you $1,500, and then if you take a deposition of that person, I didn't even put it on here, but if I have a significant case, I videotape every deposition. That costs money, and so your deposition court report charges will be coming back at $1,000 a piece for each witness you depose.
Yeah.
So yeah, obviously it gets back to what we said at the beginning. You have to be prepared to spend money.
Mm-hmm. Absolutely.
Focus
Groups. Yeah.
Focus groups is something, you know, obviously it probably started 70, 80 years ago with advertisers, people trying to sell Coca-Cola or cars or what have you. They would up pop these kind of marketing groups that would test products in front of random folks and get feedback and see how what people thought about different things. Lawyers now do that as well. And in fact, I would say, I don't know about most, but a good portion of lawyers do focus groups, and there's books on it. Here in Nashville, there's a gentleman named Philip Miller that wrote a book on it. He's a great lawyer and a great trial consultant.
Yeah, he's a friend of ours and also a client like you.
Yes, Philip knows this stuff better than about anyone in the country when it comes to focus groups.
Yeah.
So what you're trying to do is, and everyone does it a little differently. I tend to take the approach of I'm trying to learn what ordinary people are going to think about various aspects of my case. And so it might be as simple as showing a group of people a photograph and asking them what they think about it. And you can do this to where it costs a lot of money. You can hire an advertising agency. We've done that a few times. You can put an ad on Craigslist and get people in and pay them a little bit of money and feed them breakfast and present your case, practice your opening statement. I've actually, on a few occasions, been asked to teach at a local college. And what I'll tell the professor asking me to teach, you know, one class, I'll say, that's okay, I'll teach, but I want to present my case to your students. And that's what I'll do for an hour or two. I'll go in there with my case. I'll bring another lawyer in, and we'll play plaintiff and defense attorney to the class. The students like it, and they ask a bunch of questions. It's not a great representative sample of a jury, but it gets you thinking about things that you probably would have never thought of because you're in the case. So getting that outside perspective is very important. So focus groups have become a big part of modern litigation.
I sure have noticed that over we've been doing this about 20 years working with plaintiff lawyers, and it has become so big that we have several clients who've actually built kind of mock courtrooms in their office facility just to facilitate this. And one of my clients out in Las Vegas, he'll focus group a case 4 and 5 times if it's a big case to make sure he has it right, and then change his approach maybe a little bit and focus group it again. So yeah, that's become just absolutely huge. Yeah.
Exactly. So I'll just push your case to trial. That's my whole theory on maximizing the value of your case. And it's not an original theory, but it's what most lawyers that really want to do this and obtain a good recovery for their client do. And what I put down there, a continuance is the enemy of justice. That's kind of
what's that mean?
little bit of hyperbole perhaps, but whenever I notice a lot of lawyers on both sides of the fence will easily consent to continuances, and courts
Uh-huh.
do as well sometimes. And I find that when you do that, especially as a plaintiff's lawyer, you are simply either you haven't done your job and you're not ready, which is not good for your client, or you're letting the other side be lazy because they're not ready, and that doesn't help your client either if you're
Yeah,
postponing a judgment. So it's something that I avoid at all costs. There was another lawyer up your way, Mike, John Day,
sure. I
who
know, John.
told me years ago that he will grant anyone any type of extension, a defense lawyer, if they need more time for discovery or whatever it might be, but he will avoid at all costs granting a continuance of a trial. So you want to
Hmm.
be reasonable with the other side, obviously, but you've got to draw the line somewhere, and the
Yeah.
trial, continuing a trial, is where I try to draw the line. And you can't always do that. Sometimes the court's going to postpone it anyways, but that's what I
Yeah.
try to.
Well, what's the old saying? Justice delayed is justice denied, right?
That's exactly right. Exactly right. Yes, sir.
Absolutely.
And I'll tell a quick story on this next slide. And
Great.
again, this comes from learning from other lawyers. I was associated, or I was attempted to be associated on a case. An attorney from Louisiana called me probably 14 years ago, and he said, "I've got this case. It's a slip and fall. The guy hurt his back. I think he might need surgery, but he didn't go to the doctor right after it happened. A week
Mm.
after he fell, he was lifting a tire at work and hurt his back pop." And I said, "No, thank you. I don't want to help you on that." It didn't sound very good to me. And I gave him some other lawyers to call across the state because it was a Tennessee case, but it was a Louisiana plaintiff. And he called me back about a month later and he said, "Patrick, I've tried 15 lawyers across the state and no one will take the case. Will you please take it?" Well, I knew this lawyer and I knew he had a good reputation, so I agreed to help him on it. We litigated that case, spent a lot of money with the other attorney taking the lead and me helping.
Hmm.
And we get ready for mediation, and I meet him in Nashville. We go to a hotel bar the night before to talk about the case. And after a few drinks, he said, "What do you think the case is worth?" And I said, "Well, I don't know. What do you think?" And he said, "This is a 7-figure case." And I just looked at him, and I hadn't had too much to drink, so I didn't say anything. But in the back of my mind, I thought, that's crazy. We went into mediation the next day, and he said to the mediator said, "What do you guys think?" And this attorney that I was working with said, "This is a 7-figure case." The mediator said, "You're crazy." And the attorney I was working with said, "Well, if you think I'm crazy, we're going to leave." And the mediator said, "Well, hold on." We spent about 8 hours that day, and we walked
Wow.
out there with 7 figures. Um,
Wow.
that attorney believed in the case. And I
Hmm.
can't say that I actually had the same belief, but luckily he was leading the case. But what I learned in that case was, if you believe in it, you have to stick to your guns, and you've got to be genuine and authentic about it, and you have to
Hmm.
spend money. We worked that case. We traveled, I don't know how many different states for depositions, but
Wow.
he did a great job maximizing the value of that case and obtaining a very good result for his clients. So that's what I say on that slide. You have to believe in your case, and if you don't believe in it, no one else will either. So there's a
Yeah.
lot to be said for that. You have to be reasonable, obviously, but there is a lot of value to that. And every great attorney I've worked with has that same mentality. They just believe in it, and that belief becomes overpowering to everyone else involved. The mediators, the defense attorneys start to believe it too. And again, it has to be authentic and genuine.
Yeah. I imagine it's hard to fake that. People see through that.
Exactly. Exactly right.
Yeah. Makes sense. Great.
Mediation, mediation's what every case is going through these days. You're
Yeah.
going to
Seems like it.
get Yeah, you're going to get asked to mediate sometimes before you ever file a lawsuit. You're going to be asked to mediate after you file the lawsuit. You're going to be ordered to mediate sometimes by the court, by the judge, and you will, these days, a lot of times mediate a case more than once. So the old days when I first started practicing, we didn't mediate much. And
Yeah.
I think I handled 300 cases before my first mediation. Um, but now every case is mediated. But what I've tried to do over the last 4 or 5 years is try to really think about, if everything is going to be mediated, how am I going to approach mediation? And I've tried different things. And this list is kind of what I've come up with at current. who knows, it might change. You always got to evolve. But I've taken the approach now that I do not go to mediation to settle the case. And I think if you go in there to settle it, if your client thinks they're going to settle it, you're going to do one of two things. You're going to be disappointed, or you're going to settle it for less than you should. So I eliminate that by having a mindset and spend time with my client before mediation during the weeks leading up to it, advising them this is not, our point is not to settle. What really happens at mediation, in my mind, and I say be aware of what is really happening. What is really happening is the defendants have a certain amount of money they want to sell the case for. That's called their authority. And so with their authority, they go into mediation and see, at worst, can they get you to settle for their maximum authority, or on a really good day for the defendants, they're going to settle it for less than their authority. So they have, in a sense, the defendants set the amount because they go there with the only real money. And you will even hear mediators say things like, well, plaintiff's money is monopoly money. It's not real money. So you have to be aware of that, I think, and preparing your client. We have our clients come in twice before mediations to our office, or we go meet with them. One is to watch a video so they understand what mediation is, and the other is to meet with the responsible attorney or attorneys and go over what to expect and what we're going to do. So what I do with mediation is I try to use it as a tool because I think defendants are using it as a tool, so I'm going to try to do that. You can learn what the defendants think about your case at mediation. Sometimes they will share with you information that you haven't learned beforehand. They might have an expert they haven't disclosed, but maybe they'll show it to you. So I want to learn from the mediator. The mediator is someone that only has one objective, and that is to settle the case. But most mediators don't really care if it's a good settlement for one side or the other. They just want to try to get it resolved. But what the mediator can tell you, hopefully, is the strengths and weaknesses of your case from an impartial third person. So you get somewhat of a focus group. It's a focus group of one, but you get a focus group of the mediator telling you, hey, these are your weaknesses. You might want to shore this up. So a good mediator, I learn from them in that regard. The other thing is, what I do sometimes, this is becoming a little less frequent as mediations are evolving a little bit away from opening sessions. But if you are going to do an opening session, I like to use it as a chance to basically do a trial run of my opening statement. And all of us on here know an opening statement is not supposed to be argumentative. So just use the opening statement of the mediation as a practice run for your opening statement at trial, and just present the facts. Try not to be too argumentative, and that way when you go to try the case, you've already got your opening statement outlined. So that works well for me. Excuse me. The other thing is, because mediations, often there's going to be a follow-up, you want to try to leave a little bit of room for negotiation down the road.
Yeah, I imagine that mediators are happy to tell you about the weaknesses of your case, right? Because they're trying to get it settled, so they're going to try and knock you down.
Exactly right. That's what they want to do.
Yeah, makes sense. They just want to split the baby, I suppose, to get it done. So what if our viewers are watching this and any of this seems, foreign to them or new to them?
Well, I think if you're not prepared to do the things we've talked about, you're going to have a hard time maximizing the value of your case. So everything we've talked about allows you to do that.
Great. Sorry if you need to get a glass of water or something. I've been sipping mine. Sorry about that. Let me just get this off of here. So now, Patrick, if you have another minute or two, we'll open it up to questions if people have questions. We'll give them a moment. Folks, in your dialog box for GoToWebinar, you have a questions place where you can type in a question or two, and I'm sure Patrick would be happy to try to handle that for you. So we'll give folks a chance to see if they do have questions. Well, here's one. Let me reshare this. Hang on. One question is, how would someone reach you? And there's how to reach Patrick, thehamiltonfirm.com, and 800-346-7765 is his number, and I'll leave that up for a moment. Patrick, do you specialize in certain types of cases?
Yeah, we mainly do trucking litigation, and we try to handle a small number of cases and focus on significant cases. So
Yeah.
any type of commercial litigation, commercial trucking litigation is what we focus on.
Yeah, yeah. And did you start that way, or did you start with more of a general PI practice?
No, I started handling a high volume of cases at a television firm, and
Ah,
I learned after about 3 years that that wasn't for me.
yeah,
But I had about, I don't know, 120 cases when I started. And the one good thing about that is I got to try a lot of cases. But the bad thing is I had a hard time really taking each case and applying these principles that we've gone over today. And it was essentially what I call a volume practice. And so now what we do, and in fact, I've done this more and more the longer I practice, is I've tried to limit my caseload. And again, this goes back to all the things we've gone over. If
yeah,
I don't have 100 cases, but I have 30 or 40, I can go spend some time with my client. When a client calls, I don't have to just have the paralegal talk to them. I can talk to them. I can respond to emails. So it allows you to, I can go out to a scene of a wreck and take photographs. I can go meet with my experts. So having a lesser caseload and focusing and really trying to maximize the value of my cases, and that's what we try to do at this firm.
yeah,
And I find it to be very, less is more in essence.
yeah. Here's a question. Do you have a favorite author or book about trial practice?
I have more than one. uh, I think there's a number that I consider kind of the gold standard. There's Rules of the Road, obviously, which is a Rick Friedman book.
Rick Friedman, yeah.
Yeah, and I've actually read, he did another book called Polarizing the Case, which is really good.
Hmm.
He did one called Becoming a Trial Lawyer. I may be a little bit off on these names, but
Hmm.
Rick Friedman, I've never met the guy, but his books are amazing and inspirational. And then David Ball, and I
Sure.
forget, I think he might have wrote that with Patrick Malone. It's a book called Damages. And so when you're trying to prove your damages, before every trial, I go back and read that book. It's a long one, but I
Really?
read it. And the third one I would say, and I have a little bit of mixed feelings on this one, but The Reptile is a
Hmm.
book, and I'm going blank on the author, but anyone that's done any trial practice knows who it is. But the Reptile,
Keenan Ball. Yeah.
thank you, Keenan and Ball, and they do a lot of seminars. They're very good. The book's very good. I actually keep that book in my vehicle. So
There you go.
there's very good lessons in there. The only reason I say I'm a little reluctant is that book focuses almost exclusively, and the theory focuses almost exclusively on the conduct of the defendants. And I think that's really important, but I think you still have to focus on your client. And so as long as you kind of keep that in mind, I try to use all these books as tools in my tool chest that I can use different ideas for.
Yeah. One other question. Would you be willing to associate on a case outside of Tennessee?
Yes, I'm licensed in 3 states, and so we do a lot in Georgia, a lot in Tennessee. I used to practice in Louisiana, so yeah, we work on cases all over. We actually have an attorney licensed in Alabama, another attorney licensed in North Carolina. So yeah, we work on cases all over, and these, what I found, I've tried jury trials in 3 states. What I found is that the whole idea is, a lot of these ideas we presented, and when you go to trial, there's little nuances to how you might handle something, but the general principles apply state to state.
Mm-hmm.
So certainly would.
Makes sense. Great. Well, I think that's it for the questions. I want to thank you very much for joining us today, Patrick. I know you're busy taking care of your clients and getting ready for trials and things like that. So thanks for being willing to share so much of your experience with some of our viewers who might be less experienced lawyers. And I'm guessing you'd be willing to field a question or two if they were shy about asking on the webinar here, if they just give you a call.
Yeah, give me a call, or my email address is PAC, which are my initials, at thehamiltonfirm.com. I love talking to other lawyers. I really appreciate you having me on here, Michael, and appreciate what
Sure.
you guys do as a company.
Yeah, absolutely. So this webinar is brought to you by Advocate Capital. We are a team of people who believe in what plaintiff lawyers do. We help them mainly through the AdvoTrack Case Expense Funding Service. More information at advocatecapital.com. For more information about content like this, you can visit lawpracticechannel.com and subscribe to the blog there. So I want to thank our viewers, and once again, Patrick, thank you for joining us today.